Hello Kenyans, and how are you? It's yet another moment that we have so that we can get more knowledge in the area of real estate, and we are lucky enough because we have the expertise of the company's CEO, Mr. Isaac Ndua. And so today we want to discuss about something that has been troubling so many Kenyans, and that is the area of land fraud, because we understand that many Kenyans have lost a lot of money in the tunes of billions and billions. And so we want to tackle this topic so that we can get to understanding how do we get ourselves into these fraudulent land deals, and how can we eventually get ourselves out. So Mr. CEO, karibu sana.
Thank you.
And so as we start, we want to come to an understanding of, first of all, what is land fraud?
Land fraud refers to a situation whereby you find people selling properties pretending or intentionally assuming to be the owners of that land. Well, you find that these people don't have the legal capacity to transact on such a piece of land, but they assume, they lie, they mislead, they pretend to be the people who hold the legal capacity to do such a kind of a transaction. And most Kenyans have fallen victims to this, and in most cases you also find properties that belongs to deceased people. People come and pretend, some might be the heirs of such a property, but you see they don't hold the legal capacity, the legal mandate to transact such kind of a property. So you find that where someone is selling property or land without the legal capacity to transact as the registered proprietor, or without being the heir or the person with the legal mandate, either being a kid to the owner or that, such kind of a situation, that constitute to land fraud.
Okay. Now, as a buyer, how do I know that I am entering into a fraudulent land deal? What are the things that I should be cautious about?
You can be able to detect fraud as a buyer of a property by the fact that you find the questions that you're supposed to ask the person who is selling the property, they are contradicting. For example, you need to do a historical search for a certain property that you're buying, and it is through the historical search that you'll find whether this person who is selling to you has all necessary information. If, for example, you request for a green card so that you can see the history of how that parcel of land was transferred, then the person who is selling should have information that of the person he bought from or she bought from. If you see someone doesn't have the information where he or she got that land from, the information that's already available in the green card, then you can see this person is not understanding the history of such kind of a property. So it is possible to detect fraud when you're buying a property. A purchaser or a buyer can be able to detect fraud. Even the way they represent themselves and also present themselves during the sitting when you're bargaining, you can be able to see someone who is mean with the information and someone who is making you to be in a hurry to execute the transaction. You can easily be able, and even when the deal is too good, it is too good with a cost. So it is so necessary that we check and we try to have that knowledge to discern and know when we are having these people undertaking the fraudulent transaction. So it is possible.
Well, and according to your expertise and understanding, between the buyer and the seller, where does the fraud mostly come from? Where does it originate? Is it the buyer who defrauds the seller, or the other way around?
When we address the concept who normally defrauds who between a buyer and the seller, normally the person who is defrauded is the person who is offering the liquidity, the cash. In most cases, that is the person who loses. And in this case, the person providing the cash is the purchaser, by the fact that the vendors can easily be able to mislead the purchaser, and in that case, the purchaser find himself or herself giving the money, and he or she can't follow that money. In most instances, that's how it happens. You find someone even showing the wrong ground site. The title deed is okay, the title deed reads you, the vendor, but you have shown that client the wrong ground site. If the client cannot be able to physically locate the property, labda ulimuonyesha karibu na rami, na labda hii plot yako iko so much interior, but you sold to him expensive than pale ndani, but also cheaper relating to pahali ambapo sasa unamuonyesha. So you find mostly the victim is the purchaser. However, you also find purchaser who comes with an intention to kunyang'anya yule ambaye ndiye mwenye shamba. In these cases, you normally find that they come, enter into an agreement. Probably an agreement they pay 10%, and the balance 90%, you see the agreement is short of security of the vendor and overprotects the purchaser. In that case, and since the agreement becomes binding legally, you see that the purchaser, either in the corridors of justice, will have the upper hand of even saying this is what we agreed. And probably you normally find this comes when the vendor, people who are illiterate, people who don't know how to understand the content of the agreement that they are engaging themselves into. And in most cases you find such people do that with an intention to acquire that property by the fact that the 10% they gave, the vendor cannot pay back, because these are vulnerable people. They have already consumed such money, and in such a situation you find they'll immediately snatch that land, or even take that land by other means. So even there are sometimes purchasers defraud vendors.
So both the seller and the buyer can defraud each other.
It happens in both ways, but mostly it happens the purchaser being defrauded, but you also find some crooked purchasers who defraud the vendors.
So another thing, Mr. CEO, that we want to understand, can a title deed that has been acquired by fraudulent means, can it be revoked, or even can it be cancelled? And even as you answer that, let us know, was that title deed legal in the first place?
Let's come to the concept of what is a title deed. It's a legal document that is issued by the government to show the ownership of a property belonging to a specific person. However, for that title deed to be registered, there must be source documents or the instruments that gave birth or that brought to be the title deed. Now, if before the initial title deed was issued, let's assume these are land that came from a cooperative company, you see there is normally the share certificate, there are the ballots, maybe even there are some people who do sell property at the stages of the share certificate and the ballots before even the title deed is processed, and people do such kind of transfers. There could be malpractices or fraudulent activities that happened before the title deed is issued at the ballot and the share certificate level. And if there was an illegality that was committed at the share certificate level, an illegality that can be proved, that can be showed, and from that illegal transaction a title deed was issued, and that was issued illegally, we can go back to the share certificate level, proof that from that point, before the title deed was issued, an illegality was committed. That title deed can be cancelled, but this can only happen in a court of law. In some cases, you normally find the registrars even having the mandate to cancel such kind of a title deed if the evidence has tabled itself and it's clear that this came as a result of an illegality. But basically courts normally do so. If you have a title deed and it was illegally acquired, or there was an injustice that was done before it, or a title deed that preceded the one that you have, it can result to the one that you have being cancelled. And this is why we normally talk of historical search. Someone is selling you the land. Can you go and ensure that you have the historical search of that property, so that you be sure there was no illegal transaction that was done there before that can come to result your title deed being cancelled?
Okay, and something that we have also observed is that there are these deceased people who used to own land, and there's a lot of fraud that goes on with that land that belonged to people who are now deceased, but still the document are still reading their names. How does this fraud happen normally?
What you normally find is that once a person has passed away, and of course he or she left properties, and the heirs could be the kids or family members, as the family could agree. Nobody has the legal mandate to sell and transact on any property belonging to the deceased unless given such mandate by a court of law, being the administrator of such property, and having assured the court that once the court shall give the administrator the grant to transfer to the other parties who shall be the heirs, shall do so without favor, without any other interventions. And you normally find that most people, most Kenyans, but this is basically because they normally see being a cost that is being incurred to take the matter to a court of law, and the fact that you need a lawyer to assist you the concept of the succession. But you find people trying to sell such properties. Your mom has gone, your dad has gone, you think you can sell to someone, and then you go to court later and do the other matters later. Now the issue is this: what if someone sells your property and then the other family members comes and says what he sold you doesn't belong to him, belongs to us all? You see, you as a client, as the purchaser who is purchasing such land, you are at risk. You engage into a contract that can't be valid, because you are engaging into a contract with a person who doesn't have the legal capacity to do so. Is that person the administrator? Even being the administrator, you are becoming the administrator so that after the court gives the grant, you will execute the transfers by, you will transmit that land to the other heirs. So nobody has the mandate to sell a property or anything belonging to a deceased person. It has to go to a court of law, and the entire process of succession goes through. So it is illegal, it is wrong to sell, and it is also good to tell Kenyans it's not wise to buy a property belonging to a deceased. Even if you know that kid belongs to the deceased, the other kids may come and object to what you purchased from that person, the person you gave money, because it didn't belong to him alone, it belonged to the family. It is the estate of the deceased, and the deceased may have left more kids than you think. Anaweza kuwa kuna watoto wengine na huko nje, na wewe hujui, unajua hao wako hapo. Probably kuna, si unajua siku hizi watu wanaweka boma zingine kando, zinajulikananga wakati wa mazishi ama baadaye. So it's not wise to buy a property belonging to a deceased person. Tell them first of all to go to a court of law, and once they are issued with the grants, and such grants are confirmed by the court, then you can move in.
And in that case, so now who has the legal mandate to sell the property that belonged to a deceased person?
Nobody has the mandate to transact on a property belonging to a to a dead person, or someone who, or the ones we refer to, are deceased, unless the one issued with the mandate by a court, being the administrator. You get that? And after being issued with a grant, and such a grant being confirmed by the court, that this grant was issued to this person, being the administrator of the estate of the deceased, and then from then this person will transfer that property to the heirs. The heirs shall have to appear in a court of law, and the distribution, or the schedule of the distribution of the property, must be presented to the court by the family in agreement, and all of them shall be asked in a court of law, have you agreed on this, the way the property has been distributed, or the schedule of the distribution of the property, and each shall have to confirm. So the only person who has the legal mandate is the administrator, but it is after he or she has transmitted those properties to the heirs, and now the heirs can sell. Actually, transaction should happen after registration of RL7. Yeah.
So Mr. Director, just help us understand, what is the procedure of succession so that someone acquires the legal mandate to transact land that belongs to a deceased person? What is the legal procedure of succession?
Now, the procedure for a succession starts with the family coming together after now having the the issue of having the burial rights and ensuring that the person who is deceased has been buried. Now, the family goes to a chief, the area chief, who recognizes the family and recognizes the kids as the heirs, and now gives a letter addressing to a court of law and introducing the family to the court, to the magistrate, and informing the magistrate that these are the heirs that were left by the deceased, and request the court to assist in the process of the succession. In that case now, the family can get the services of a lawyer who will prepare the documents for the succession, files those documents in a court of law, and then of course the administrator, in that case the lawyer will give the name of the administrator as agreed by the family, and make all the documents, sign, let the administrator and the heirs to sign those documents. Once the documents are in a court of law, what happens is that the court now accepts the administrator by the fact that the family has brought the administrator to the attention of the court. It is now gazetted in a Kenya Gazette for a certain period of time. Probably normally is 3 to 6 months, and then after the expiry of that period, now the family goes back to the court by the fact that now the court has seen that nobody came to object the advert or the information that was fronted in the Kenya Gazette. Now, in that case, once they come to court, the court issues a grant, and the grant is issued to the administrator. Okay, the fact that he is the person now who can stand before a court of law and talk on behalf of the family. That is why we normally have the administrator of that property. But the fact that you are there as the administrator, it doesn't mean that the property belongs to you. It's only that you are the point man or the link between the court and the family. You can be asked a question. Now, all the heirs of that family now shall come to the court of law, and each shall be called upon the name, with them introducing their IDs before the magistrate, and the magistrate or the judge in that case reads the schedule of distribution of the property of the deceased, and they have to confirm each whether they are in agreement with the same. If they are in agreement, then the court shall confirm the grant that were issued there before, and a certificate of confirmation is issued by the court. The certificate that is now the certificate together with the grant and then with the copy of the Kenya Gazette are normally taken to the registry of lands of every title deed. You know, the deceased could have various properties in different regions, so such title deeds could be registered with different registries. So you take those documents, that is the certificate of confirmation, the grant, the Kenya Gazette, together with a document prepared by the lawyer known as the RL19 that now introduces the administrator in the registry and recorded as the administrator. Being an administrator in this case means that it is an institution. You are an administrator at the same time you can be the heir, or you can also be the heir, and you'll also have a property there. By the fact now you register the RL19 with the registry, in that case now you can maybe if a property requires subdivision, you can now engage the process of the mutation, meaning the deceased left one property that need to be subdivided so that can be transferred to the heirs. Then you need to register the RL19 around, and then you do the mutation, so that after the mutation gives the new person numbers are issued, now you can register the RL7 after the person numbers have been issued, so that now the title deed can be printed by the registry containing now the new person numbers together with the way the distribution schedule was issued. However, if for example the administrator in this matter is a wife and taking the entire estate of the deceased, then we have to register the RL19 and RL7 together jointly, because there is no subdivision that need to be done to any property. So you register both of them. And what you need to understand is that when we are talking about the administrator, an administrator is an institution. Despite being the fact that the administrator can be still the only heir of such a property, the administrator is an institution shall transfer the same property to himself or herself. So it's good to know that being an administrator doesn't make you to be the owner of such a property until the institution, the administrator, now transfers to you that property. And it's from there that now a client can comfortably now pay for such a property because it has undergone the entire process, the legal process in a court of law.
Well, as we come to a conclusion, help us understand, because there seems to be a lot of forces that push Kenyans to the corner of being defrauded of their land. Last year there was a situation that came up whereby a land registrar defrauded innocent civilians of their land. That was in Baringo County. He was finally convicted, but that shows the depth that things are going, such that they push Kenyans towards a corner. There seems to be so many factors that come into play. Maybe you can explain to us, what are these factors that come into play that are pushing Kenyans to the corner of being defrauded of their land?
Now, some of the forces that result to forceful acquisition or forceful transfer of property from the poor Kenyans, you normally find, as you've said on the case in Baringo, you find a person in an office misusing the powers and the privileges of such an office by the fact that that person knows the registry and knows the register and knows what is entailed in a register. And even such a person could, as you said, a registrar, could be in a position to well know the position of a proprietor, and even by ways of coercion or misleading results to a property being transferred to his name or her name. These are people with the power to see what is there in the register, the people who have the power even to execute and be the people who are signing these transfers. So those are some of the forces that are resorting to this. Now, the other forces that we can talk about is poverty. You find a person for sure has a property belonging to a deceased husband, but this lady has no money. Even money to do even a normal search or even a request for to register a restriction or a caution on her property that is being transferred. Poverty is resulting to most Kenyans finding themselves that some poor people, I mean some corrupt individuals or people with money getting those properties from them. Because of poverty, and you find such a Kenyan can't be able even afford to get a lawyer to file a case in a court of law for that. The other thing is corruption. We found ourselves in a situation whereby some people, some brokers somewhere working together with the registry. Their work is to identify lands belonging to poor Kenyans. Na kazi yao ni kuwasumbua tu. They go give money in the registries, results to land being transferred, and in these cases they don't transfer the land generally to them. Huwa wako na ukora sana. You normally find such people, anaenda anasema hiyo shamba nilikuwa nimeuziwa na ilikuwa imenunuliwa na mtu fulani, huyo mtu akauzia mtu mwingine naye ndiye aliniuzia. So they hide themselves through some various levels.